Bill Henshaw here again for the Constitutional Crisis channel, and this video today is on one of my personal pet peeves, and that's the issue of recording in a quote-unquote court proceeding. Now here in California they have some local rules that ostensibly say you can't do it. Now the problem with those rules though is that they're promulgated by the quote-unquote Judicial Council of California, and they don't have any authority to do it. Even if they were judicial courts, and they're not. And that's one of our main reasons for invoking our right to record these proceedings, is to prove the acts of treason they're committing. But the Judicial Council, quote-unquote, that's an arm of the government of California, whether it's a state or a territory. If in particular it's a territory, they would have to be appointed by the president under the Appointments Clause, Article 2, Section 2, Paragraph 2, and none of them have been. Therefore, no authority. Number two, they're a direct adjunct to the quote-unquote State Bar Association, what else is new, and therefore they have a not only vested interest against us, they have irreconcilable conflicts of interest to keep us from being able to prove the acts of treason going on in their quote-unquote courtrooms. Now remember, these are public trials, and it seems to me if they're public, I mean that's the very definition of the word public. There's no privacy rights involved here. There's nothing they can invoke to protect themselves, and especially since this is the only way that maybe we have in order to establish our burden of proof to get convictions against them for fraud, if not treason. So I think we have every right to do that, and we have a particular right, in my own personal point of view, to do that in what is otherwise a secretive hearing pursuant to the competence of the accused to represent himself, quote-unquote, in a criminal proceeding, quote-unquote. You know, that's good old Faretta v. California that comes into play there. And, you know, the judge, quote-unquote, thinks he has the power to make a determination of your competence in a secret hearing with nobody present in the courtroom except attorneys, of course, and the bailiff, whatever, but no public is allowed in there. This is where it's most needed. If they're going to have those kind of hearings, and by the time I get through with them, we're going to see to it they don't, but at the moment, they still think that's what the law is. You know, it's out here, that's people reading Marsden, it's the California Supreme Court saying it. So they're going to presume at one and the same time, we're incompetent to quote-unquote represent ourselves, and yet quote-unquote competent to form the requisite criminal intent to have committed the crime. I mean, you tell me. Back to the issue, however, if we can't go in there and do this, you know, and you have, and especially with traffic courts, quote-unquote, which are not, in California at least, courts of record, although they're supposed to be, even if you read Article 6 of their version of the California Constitution, they're not. So there's no record being set there. And I think even if you get a court reporter in there, that's inadequate, especially in the 21st century here, because all a court reporter can do is take down what they thought they heard you say, and I try to be very slow, like I'm trying to do with videos, to elucidate so you get every word of what I'm saying. But I have transcripts that will show that errors occur here, and some significant ones. What we need to have is recordings, audio and or visual, because now you not only get what was said, but how it was said. And that, in my mind, is much more important than any other element that goes on here, because if you don't have that, you know, then you don't, it's very hard to make a determination, especially for jurors if it comes to that. But in any case, you know, all this crap with these local rules that say you can't record, you know, I'm not buying it. And, you know, I may end up challenging this myself directly by bringing a recording device in and attempting to do that. I mean, what are they going to do if they're not a judicial court and they're going to try to hold you in contempt of court? Then you stand right up and ask the quote-unquote judge, using his proper name, what exactly judicial power it is he thinks he has in a territorial legislative tribunal. There's no contempt powers there. Can't be. I mean, that beats him, and my record is established. We got no judicial courts here. So we all the more need to be able to do this in order to preserve our rights and get our records before a judicial court, even if it's only on appeal, which I'm not in love with, and we've discussed this matter in other videos. But we've got to be able to get it there and get the issues properly before the courts, particularly the Supreme Court of the United States, so that they can make a decision. Although left to my own devices, by the way, I'd much rather have these videos in front of 12 members of my peers in the jury to make a decision as to whether these quote-unquote judges and DAs have committed treason. That would be much more effective, and they know it, and that's the real underlying reason for the rules. So that's a big change I hope we see soon. And you can go into court and whatever you want to do in the way of recording, you can do it. You don't need a court reporter. You don't have to pay one. And by the way, in California, they have a hell of a strong political industry here. I mean, a lot of clout, a lot of PACs, and up there in Sacramento, they're a presence because they want to keep their jobs, and their easy positions, which they have. So it's a bit of a problem. And in earlier times, by the way, quick aside on this subject, and if you look it up, it'll be an interesting case to read and study, the case of Carol Chessman, who was called the Red Light Bandit, because of some murders he supposedly committed in the late 1940s, I think in the context of stealing automobiles at the same time. And it looks like that Chessman may not have committed any of these acts for which he was convicted and sentenced to death. And by the way, at the time, he was the person that had been on death row the longest when they finally did execute him in 1960. And I remember seeing this at the age of 11. And he exhausted his appeals. He'd been before the Supreme Court 2 or 3 times and finally ended up losing. But the big deal here was that after the trial, quote unquote, the reporter who took all the notes for the trial passed away. And Chessman made a very good argument that the film reporter that came in behind him had no way to accurately make a transcript of the trial proceedings. And this dragged on for 10, 11, maybe even 12 years before the courts finally ruled against him. So this is how important this business is of recorders. If we would have had the means, and actually we probably had them even back in the 1950s, to have made recordings, even if they're kind of rough by today's standards, Chessman may have come out a whole lot better. But the fact he might well have been innocent, which doesn't directly relate to this, is a matter of some historical interest as well. Because it appears not only that that was true, but that he got royally screwed by the quote-unquote trial judge, one Arthur J. Fricke, who later wrote the damn book on criminal procedure in California, and obviously didn't follow it himself. But it's an interesting case. You can Google this one. Just write Chessman v. Teets, Teets. Teets. This will pop right up on the on Google Scholar, and you'll get the case, and you can read it. There's 2 or 3 of them. You should read all of them that are in there. Interesting stuff. Now, a continuation to the video discussing, the ability to record court proceedings. If it's going to be decided against us, then your best protection is at all times to do it. You can take a witness or even more than one to sit in. And I would do it and provide them with 8.5 by 11 legal yellow pads and have them sit in the front rows. The black robe bastard knows they're there, and making a record that they're going to later make affidavits of, which will be relevant, admissible evidence as to what went on in this proceeding, especially in a quote-unquote traffic court. But this is true, and particularly true in a quote-unquote criminal court, too, because you're going to be raising issues there that they don't want to hear and they don't know what to do with. So if you can do that, at all times, I would encourage you to do it. And this goes back as far as the Old Testament. I believe it's Deuteronomy, where one of the verses in there says, at the mouths of 2 or 3 shall the matter be settled. I think that's a good rule for us to apply in this day and age as well. And you'll be much better off for it. Now, I should also add that most of what I've been talking about here you can find in the notes below, the cases I talked about and some of the references. So please feel free to consult those. And if you have any questions, feel free to contact me at my email at ccaspari@live.com. That's ccaspari@live.com. Thank you.